became the file. These petitions were fixed for a mention on 29th of October 2024 for the parties to decide on the way forward depending on the outcome of the proceedings before the Senate. As it is, the Senate proceedings ended with the impeachment of H.C. Gachagua. As a result, several other petitions challenging that process were filed. We shall hereinafter refer to such petitions as those in Cohort 2. Those are the petitions that were consolidated, and constitutional petition number is 565 of 2024 became the lead file. Having considered the nature of the petitions before us, and with a view of conducting those proceedings in an orderly manner, we hereby issue the following further directions. 1. All the petitions shall forthwith be dealt with as those in Cohort 1 or Cohort 2, respectively. 2. Court shall, pursuant to Rule 17 of the Constitution of Kenya, Protection of Rights and Fundamental Freedoms, Practice and Procedures, Rules 2013, on its own motion, consolidate any other petition referred to this bench into any of the two cohorts. 3. For clarity, the petitions are hereby consolidated under the two cohorts as follows. Petition in Cohort number 1, Nairobi petition number E522 of 2024, that is the lead file. Then we have Nairobi petition number E506 of 2024, Nairobi petition number E509 of 2024, Nairobi petition number E525 of 2024, Nairobi petition number E528 of 2024, Nairobi petition number E537 of 2024, and Nairobi petition number E541 of 2024. The petitioners in those consolidated petitions are as follows. 1. Rigathi Gachagua. 2. Obuli Namea. 3. Kennedy Kamithiu Gachege. 4. Dennis Okumu. 5. Simon Muchangi. 6. Peter Maina. 7. Gema Watho Association. 8. John Mugo Kiragu. 9. Njomu John. 10. Caroline Wambui Mwangi. 11. Dr. Clarence Eboso Mwaresa. 12. Wanjiru Mwangi. Those are the petitioners in cohort number 1. Respondents in that cohort are 1. The Speaker of the National Assembly of Kenya. 2. The National Assembly of Kenya. 3. The Speaker of the Senate of Kenya. 4. The Senate of Kenya. 5. The Deputy Speaker, National Assembly. 6. Honorable Moses Masika Watangula. 7. Honorable Amason Kingi Jeffa. 8. Honorable Attorney General. The interested parties in that cohort are 1. William Samoei Ruto. 2. Law Society of Kenya. 3. Mount Kenya Jurists. That is cohort number 1. Petition in cohort number 2. Nairobi petition number E565 of 2024, that is the lead file. Nairobi petition E550 of 2024. Nairobi petition E570 of 2024. Nairobi petition E572 of 2024. Kerugoya petition E013 of 2024. Kerugoya petition E014 of 2024. Kerugoya petition number E015 of 2024. The petitioners in those cohort 2 are as follows. H.C. Rigathi Gachagua, number 1. Number 2, Thomas Kimotho Maingi. Number 3, John Hon Jane Jerry Maina. 4, Hon David Munyi Mavenge. 5, Peter Gichobi Kamotho. 6, Grace Mudhoni Mwangi. 7, Clement Mchiri Mureki. 8, Edwin Munene Karioki. 9, Sheria Mtani na Shadrach Wambui 10, Father Eddie Waiguru. From 10, you note that Father Eddie Waiguru is in the list of E570 of 2024, and there are 32 petitioners. So from Father Eddie Waiguru, we add all the petitioners in that petition, which come to 32 and ends with Gema Watho Association. Respondents in the court 2 are as follows: Speaker, National Assembly of Kenya; 3, Speaker, Senate; 4, Senate of Kenya; 5, Hon. Attorney General; 6, H.E. William Ruto; 7, Clerk of the National Assembly; 8, Deputy Speaker of the National Assembly; 9, Hon. Mwengi Mture; 10, United Democratic Alliance; 11, Orange Democratic Alliance; 12, Kenya Kwanza Alliance; 13, Ford Kenya Party; 14, Amani National Congress; 15, Register of the Political Parties; 16, Independent Electoral Boundaries Commission. In that cohort, the interested parties are follows: the Law Society of Kenya, Professor Kithure Kindiki, Wiper Democratic Party, Jubilee Party of Kenya, Katiba Institute, Mount Kenya Jurists Association. And then lastly, Kituo cha Sheria. Pursuant to those, we direct that all filings and service of documents shall be done electronically through the court's electronic portal in the respective court's lead files. Parties shall accordingly ensure that they are duly marked into the system. The Honorable Deputy Registrar of this division shall assist if need be. Any counsel or party appearing in these petitions shall, before the start of any court proceedings, record such appearance in the quorum forms that shall be provided by the court assistants in this bench. Those appearing virtually shall as well log in and register their presence through the court assistants. As directed on 23rd of October 2023, any application in either of the cohorts seeking the recusal of the judges in this bench shall be heard today at 2:30 p.m. Those directions can be accessed in this court's electronic platform. These directions can be accessed in this court's electronic platform in the respective lead files. This court shall give further appropriate directions in the respective cohorts' lead files as and when necessary. Thank you very much. The directions, subject to amendments which have come from you, will amend it and then upload it.
Yes, my lord, with your kind permission, if we may be allowed to address the court. My lord, we are guided by the directions issued by the court. We, however, have one concern from our side, my lords. My lords, there are interim orders that were issued in Kerugoya, and in our understanding, from our interpretation, once the file was referred to this court, the orders expire today. That's our understanding. And my lord, we are going to seek the court's guidance on the hearing of our application dated 18th October. Of course, we understand that there is a recusal application today. But given the fact, my lord, that our interpretation is that those orders would expire on the appointed date, which is today, when the matter was meant to be mentioned, our colleagues' understanding, my lord, is that the application, in the public interest, be prioritized so that we are able to hear the application for setting aside of those orders. In any event, my lord, the orders in question were issued by one judge. The matter has now been referred to a 3-judge bench. And their nature is problematic. as mentioned by the court. And we would pray that in terms of aligning the hearing or scheduling the applications to be had in cohort 2, that if possible, my lords, we do not want to do anything outside the law. We would request, my lord, that we be heard today if it's possible, because the orders expire today. I think my lord Friend Gumbo would just want to add something on that.
My lord, very briefly, I wouldn't want to repeat what my lord, I just wanted to indicate that I would not want to repeat what learned senior counsel Professor Tom Ojenda has indicated, but just for completeness of record, there are two applications. There's one by the Honorable the Attorney General and one by the National Assembly dated the 18th of October 2024. We are ready with that for them as soon as you direct, my lord.
My lord, with your kind permission, Daniel Manzo, appearing for the Law Society of Kenya and also for Wiper Democratic Party or interested parties. My lord, if the orders are to expire today, then that will be at midnight. My lord, the day is not yet over. We have applications in the afternoon. We are also affected by those orders. And my lord, I suggest after the applications today, then we can discuss that matter before the court adjourns. I thank you, my lord.
My lord, Kibe Mungai, on behalf of the petitioners, there are two issues. You can see the senior, the team leader, Honorable Paul Wite is not with us in the council. That is the first thing that we deal with it in the afternoon. And as far as we are concerned, the matter is premature, and the hearing and determination of that applications for the simple reason that the issue and an order had already been made that will be first dealt with by the court after its ruling of yesterday was the application for recusal. The other matters that relates to how we shall deal with the petition, and we shall deal with all the applications, including the first application for conservatory orders. Those are matters that, as far as we are concerned, are supposed to be dealt with by the directions. By this bench, if it continues, or by any other bench. And therefore, the issue, my lord, of a back and forth on what is to be had first, the court has already ruled on that. And I believe we need to stick to that. And I am lamenting that even as we sat here, because we have started a little bit late, there is some work we still needed to do with regard to the applications for the afternoon. So we would like any other businesses that is supposed to be done when, for example, Paul Wite is in the afternoon, it will be dealt with in the afternoon. But my lord, on the directions, the actual directions that have been given by the court, there are three things actually that we would like our reactions on behalf of the petitioners. Number one, my lord, is that in giving these directions, we are understanding that the directions are being made pursuant to the rules of procedure that are applicable. My lord, under the rules of procedure that are applicable, a lot of the petitions that were filed before last Friday, the ones that were filed even on Friday last week, are maturing their last dates for responses. My lord, as we sit here, we are yet to receive any substantive responses to those petitions in either halls from the respondents. And that will have an impact on how soon we can be able to deal with the substantive matters. So my lord, I would be expecting that as a further direction, everybody would be required also to comply with the Mutunga rules to the full. Now the second issue is that in all the petitions, the subject matter was the impeachment proceedings. The impeachment proceedings was culminating with the impeachment that was done last Thursday and the facts as they happened on Friday. A lot of these petitions would require some amendment so that they conform with the last petition, so that they are not termed as academic. So that, my Lord, towards that, the petitioners, including in the petitions where I'm participating, we have requested formally that we would want 3 days to ensure that any amendments are carried out, and then the respondents will indicate, they have been saying they can do things within a day or two. They will indicate how much time they need to do the responses, because, my Lord, that would assist in ensuring that whichever bench is going to hear and determine this matter would be able to give final directions, because, as we have said, these are interim directions. And number 3, in order to be able to determine issues for determination, and these are the issues that we deal with when we are doing pre-trial, issues for determinations that are essential in a matter with so many parties, that would require close of pleadings. And the close of pleadings means that all the responses must be given. So that, my Lord, as far as today is concerned, I urge you respectfully that the first thing that can ensure we are moving forward is to ensure that the responses, in accordance with the Mutunga rules, will complete that journey. My Lord, if that is done, it is my view that we will be able to make some progress. In the meantime, my Lord, unless there is any other matter, because there was no other matter that was to be dealt with except directions, we would be happy to leave this place as soon as possible so that we are ready in the afternoon. We are most obliged.
Just before leaving.
Senior, because I'm on the same side, perhaps you can have some response on it. Your Lordship, for purposes of clarity and for purposes of not addressing the gallery anymore, permit me to draw the attention of Council for the Senate to the notice of motion that was filed in respect to the conservatory orders that were granted. The judge sitting in Kirugwe, Your Lordship, was categorical that he granted prayer number C, even as we await Senior Counsel Paul Mojo to come in the afternoon. The wording of those prayers was so explicit that if my good professor had the opportunity of interacting with the document, which I believe he has not, would have come to the conclusion that the orders were drafted in this manner, that pending the hearing and determination, of this application inter parties, this honorable court be pleased to grant the orders that were granted. That is therefore to mean, Your Lordship, that question that Senior Counsel is raising has no sitting in the pleadings before you. Number 2, Your Lordship, since we are here for mention and in the afternoon we are coming for the application for recusal, and I have had the advocates for the respondents insisting on the urgency to hear the application for setting aside, Your Lordship, it is important for the court to note that that application is not predicated on any response. And therefore, if I were them, I would be seeking guidance on how to file their replies. Your Lordship, I hope you are following.
Following.
He doesn't seem to be following.
Why do you say that?
But
Why do you say that?
let me leave it at that.
Thank you. I think that is... Sorry, gentlemen. You cannot talk forever.
My Lord, on a very small issue, we do confirm that for His Excellency, the Deputy President, Gachagua, as the petitioner, we have not received responses from the respondents. So it is important that first of all we get directions for the filing of responses, because as we speak now, we have not received those responses from the respondents. Then number 2, my colleague Senior Kibe has raised issues on filing of responses, so that in 522 we had given an indication that he might require to amend our pleadings, so that before the ruling that was delivered by this bench, there was indication that we might require to amend the pleading. That is in petitions in cohort number 1, so that if the court can grant us leave, within 3 days, those amendments can be done. And thereafter, this can also probably affect in some petitions, cohort number 2. So it is important that we get that particular direction. Finally, my lords, this proceeding, because of the nature, the way they are proceeding, would request that probably we be provided with sequentially the transcribed proceedings, so that in case we require the proceeding again at any time, those can be availed for purposes of good order. That is all.
May I say something?
With due respect to counsel, we did not intend to make today this hearing a long hearing. We have been courteous enough. We have read our directions, and I think you should let us wait for proceedings in the afternoon.
Sir, I have something to say. Number one, the petitioners cannot approbate and reprobate at the same time. They are calling upon the respondents to file their responses. At the same time, they are seeking leave to amend the petitions. How would petitions that are to be amended be responded to when actually it should be the amendments that should come first and then responses follow? Number two, we brought to the attention of the petitioners that the interim order, one of the interim orders expires today, and the other one is the one we are complaining about, that it is actually aggrieving the respondents and should be set aside, the Kirogoya order. Therefore, we shall be delving into that as soon as it is practicable. And number three, the reason why we are here and from the day before yesterday is due to the applications that were filed on the 18th of October to set aside the ex parte conservatory orders. Therefore, that agency cannot be lost or cannot be clouded in whatever else they are saying. It is our position that we should actually proceed and be heard on why those conservatory orders should be set aside. Thank you.
I apologize. When I made an application for the project, I let them join. My Lord Justice Okola, you are very kind now. You promptly allowed my application. The project was to be joined. The offer was to be joined by my name. You have not mentioned this. If you would be kind enough.
In which petition?
Yeah.
In which one? Which cohort?
This, I'm sorry, I don't have papers.
We'll enjoy you. In your own name?
Yes, it's my own name. John M. And of course it was in
So you are petitioner number 8? No. Interested party number 8?
Party number 8.
Yes.
That's all. Thank you very much.
Thank you, my Lord. We just want to restate the position that the agency in this matter cannot be gainsaid or cannot be lost, my Lord. Under the condition that the replies have not been made, that we have not made the replies, is not correct because we have filed our responses. And my Lord, at the end of the day, the very essence that led to the empanelment of these churches will actually be lost, because then we would be going back and forth, and at the end of the day, my Lord, we will not have served the greater public interest or the greater public good that led to the empanelment, which you made a determination yesterday, my Lord. We would urge that we be able to proceed and argue this matter conclusively and rest it once and for all.
Thank you. We are no longer accepting any further submissions. I'm saying this, that it is not for court to direct parties when to respond to pleadings. It is not for court to direct parties when to respond to pleadings, but one thing which I can assure you that this bench will not allow anybody to take the process of court in circles. So if you have been served with a document, whether petition or an application, if you don't respond, the court is allowed to infer that you have no response. If a petition has been filed and you have not responded to it, the court will make inference that you have no response to that petition. And by the very nature of these proceedings, we all acknowledge that they are public interest proceedings. No party will be allowed to take the court in circles. So I ask you, respond to the pleadings, file your petitions, respond to them. Don't come and ask for leave in a manner to suggest that you want to take this court in circles.